a training session for the Board of Ethics on the Ethics Code. Present are
Robin Phillips,
Keith Silver,
and Deanna from Department of Law, along with,
Julia Tucker, Assembly Counsel.
and Barbara Greenstein, the school clerk.
and we asked, the Ethics Board asked if Julie would come in and give us some additional insight as one of the drafters of the code, and one former training session, and a very intriguing sort of discussion with the Assembly at one point in time with the Ethics Board, and we realized we really wanted additional input. I did pass on some questions to Julia yesterday, just some general discussions at the end of our meeting.
Okay, this is Julia. I'm going to pass out a couple of things which everybody may be familiar with, but just in case, if we need to refer to them, I thought it would be handy. And then,
Okay.
did you bring
I did.
copies of?
I did.
Okay, so the first thing I'm passing out is the outline of the Ethics Board resolution process. And this is a form that's kept online and in the clerk's office. And the genesis of this is that the sponsor of the original 2007 code revision, Ken Stout, requested that prior to the effective date of the ordinance, that we provide an actual, in this sort of form, bullet, layman's term of what happens when you're on the receiving end of an ethics complaint and what to expect. And so this was actually a helpful exercise for us because we could go through what we'd written out in the code and then try to explain it and make sure that the code. Barbara, do you need a copy?
I can get one tonight.
Okay.
Yeah.
Just sort of explain, and what his idea was that people who are on the receiving end of a complaint, they shouldn't have to go to an attorney to explain what's going on, and they sort of need a guide. And he thought that it was helpful to have this up front instead of having it be put together after the fact as needed. So this is one of the forms. As I said, this is like called a form.
Now,
and
is this on the website then?
And it is on the website.
Okay.
I read it yesterday.
And I took it off the website today. And it's also,
You printed it off the website?
I printed it off the website, yes.
As opposed to physically taking it off.
No, I'm sorry, yeah, I did not remove it from the website. I pulled it down and printed it from the website. And it's one, somewhere I think, I didn't look it up today, but in the ethics code it sort of says that there's this resolution process and that they can get a copy of it from the clerk's office, and the clerk's office has conveniently put it online. So,
Okay, and and the Ethics Board sends out the notice of or do you do that, Barbara? That, for instance, the letter that was going to go to the last two
Marissa
respondents.
drafted it. Shayla printed it.
And does he attach this?
I don't know if he did it or
Okay, we
not.
might check that.
Yeah.
Because right now they're sending out sort of a cover letter saying we'd like you to come to the next board meeting to ask you some questions. So here's attached his copy of
A notice of potential violation.
with a very quick
right, I think it
this.
was contemplated that this would go out to anybody who
Okay,
was
so we should probably keep
receiving
that
it.
in
So you
mind.
want to maybe provide instruction to the clerk's staff
office,
on
okay.
behalf of the board to ensure that that's
Yeah.
happening, because that was envisioned by the code.
It makes sense that it goes with it, because depending on the individual, this could be a scary thing.
Oh, I think it's scary to anybody.
Yeah,
That's
to anybody it's scary, right? And also it helps to go with if as you get into the investigation, or if there are people who, additional people that you're going to want to call, is to just make sure that in any notice that is sent out for them to participate, that they get a copy of this, so they kind of see what, where you are and what's going on. And then should you want to make changes to it, that's easily done too. But this at least gave a beginning point to that kind of a format. Then I asked Dee to copy so that everybody would have a copy to
They
look
have
at
copies
today.
already of this.
This advisory opinion 2007-3, which was one of the.
Oh, I'm sorry, I got the
No, that's
wrong one.
not-
I have 2007.
That's not what we have.
Yeah, 2007-3.
Okay, let me quick go get that for you.
Do you want
Or do you have it?
Do you
Yeah.
want to? Yeah.
Let me
You
quick.
can just Yeah, just
Kind
maybe
of wonder
copy
what we got
that.
the one about
Yeah,
the
right back. I'm sorry. I cut the wrong-
Mayor's brother, but okay.
Yeah, no, the first major one on gifts, and I think that it set an important precedent for the entire board going forward on how the code language was to be interpreted about gifts and where gifts are called out and where they're not, and
Are you aware of what we've been doing on gifts just in the last several months?
No.
And of course, the gifts are primarily with
With the school district, that's the issue. Well, okay, and I was explaining to her what we've been doing on gifts recently, and we've pretty much taken a line, anything over $50, the teachers are getting a letter. It's an explanation. That,
Right, and I think
might
that
be-
this opinion is going to support that.
Yeah.
And that's why I think it's important to know and be aware of the advisory opinions that have come out, even before this particular board was put together. Because just like with any code, you're going to have the law as it's passed, and then you're going to have the interpretation. And those advisory opinions are sort of the equivalent of the judicial interpretations, and
Sort of case law.
they're your case law, and where they're on point, they should be followed. Where they're going to not be followed, then you want to formally recognize them, just like a judicial opinion does, and say, these facts are distinct from when we looked at this issue and blah blah blah, or this is analogous and in keeping with this decision. And so I think that when Dee mentioned that the school board gifts were important, I thought that it was important for you guys to for the board to have, and we'll kind of go over that in more detail. And then there was kind of a question before we get into the school district and gift disclosures, which I figured most of our discussion would be on today. There was a question that Dee raised about the difference between in section 1.15070E. And does everybody have actually a copy of the code? Because I brought some extra copies in case you don't.
They're pretty good about it.
Everybody got one? Okay, so,
We get our hands slapped if we don't bring them to the meeting.
yeah, okay, good. So what did I say there? 115.070.
Oh, with respect to the standard approved with respect to preponderance and substantial.
And 6 and 8.
Right.
Because other than one member of the board, we're not attorneys.
Right. And so,
Other than
right, so I'm
Let's see that here.
gonna
Keeps us
pass
straight.
out the third thing that I brought today to help us in the discussion, and that are the references to how substantial evidence is defined in other places in the code for other boards. And so the genesis of this is that when we were passing the code, or when we were having the ethics board review the code and give comment to the assembly before the assembly passed the 2007 revisions, there were a lot of discussions about substantial evidence and also about the burden of proof. And substantial evidence and the substantial evidence test was woven into the former code, and the Board of Ethics thought it was important to go ahead and have it referenced in this code. And so this is going to be my intuitive explanation of how this works, is that on the one hand, you have the burden of proof. And that is generally something that may go to the jury or the trier of fact. And the generally accepted three standards are by a preponderance of the evidence, by clear and convincing evidence, and beyond a reasonable doubt. And preponderance of the evidence is generally acknowledged as that tiny feather of weight that balances the scale, and it's the least onerous burden of proof, and it's used generally in civil actions. On the other end of the spectrum is beyond a reasonable doubt, and that's...
Excuse
Go
me.
ahead.
So in a case, if you had, in a civil action, if you had a jury trials happen in civil actions as well?
Excuse me?
Do you have a jury trial in a civil action as well?
Yeah, you can have a jury
But
trial.
the jury does not have to be unanimous in a civil action. It's just am I correct? The jury doesn't have to be unanimous in a civil action. It would just be the majority.
The voting requirements are different. Civil does generally have to have 10 out of 12.
Okay.
But those are different than how you weigh the evidence. So voting requirements are different, but again, they're different than this whole issue.
Okay, so so I'm going to back up one more step. In most adjudicatory court actions, whether they be civil or criminal, there will be a right to an appeal. And the appellate court looks back and says, okay, the standard of proof going forward that was applied to this case is the preponderance of the evidence in the civil case. And that doesn't come up very often as an appellate issue. The standard of proof in a criminal case is beyond a reasonable doubt. That's on the other end of the spectrum. And sometimes it looks like it's beyond all unreasonable doubt, but it's supposed to be beyond reasonable doubt, right? Then in between there, for some court actions, there's a standard that's higher than preponderance of the evidence, but not all the way, and that's this clear and convincing evidence rule. And that's for some special things.
That's like fraud.
We don't have to worry about, yeah, but like fraud. Okay. So those are the tests that you apply, because when you're sitting there looking at evidence, and one guy says one thing and one guy says another, one person says one thing, one person says another, and you're having to weigh it, you are going to have to decide which is more convincing. And then when they're so equal, you have to decide, okay, what standard? Does it have to be like this, beyond a reasonable doubt? Or do I just say, okay, this one's slightly more convincing than that one? And so that's your standard of proof. And the standard of proof applied in these cases, when you look at it, is that lesser standard. It's that feather of difference that says we're going with this one. In a contested case, we're going with this one because it's ever so slightly, that pebble, that mark, that feather, whatever that is, it's there and it convinces us. Okay. Now, the other thing is not a standard of proof. The substantial evidence test is not what we've already gone over the things that you apply here on the spectrum. This is something that does get looked at by an appellate court when we're talking about a court situation. We don't really have an appellate situation here. But it's a secondary test to apply to yourselves, which is that no matter how it weighed out here, no matter how the evidence weighed out here, you have to have reasonable evidence to support your decision. It can't be preposterous evidence. It can't be that, well, some guy came in with a preposterous story and the other person came in with a preposterous story and one is slightly more credible than the other. If none of them are credible, then you didn't have substantial evidence to base your opinion on. And so that's why I passed out these things, because the top one is used by the Board of Adjustment, who again hears appeals. It's an appellate board, not quite analogous to you, although there is no appeal to. I mean, the decisions here are not going to be here, but it's a safety valve because in applying the code to you that says the standard of proof is preponderance of the evidence, and the board's finding of a violation must be supported by substantial evidence. That means that it has to be relevant evidence as a reasonable mind might accept as adequate to support a conclusion. And it's just a safety valve because not everybody is an attorney, and even attorneys can get carried away. And so the decisions of the ethics board are not going to be binding, are not going to be legitimate decisions of the board if they don't meet the substantial evidence test. There has to be relevant evidence as a reasonable mind. It's a reasonable person standard. So when we were talking to the ethics board about this before, I sort of tried to combine those and move it to one clear and convincing evidence. Because I thought it was just hard to separate out the quantum, the reliable part and over here. But my attempts at having to move that into just raising a higher standard of evidence failed. And so what the Assembly and the Ethics Board came to mutual accord on was to include both of these things in the code. So that feather of weight, that the lesser standard to find a violation, but when you find a violation, that evidence that supports it has to be reasonable. It has to be a reasonable mind found that and not carried away by unreasonable things.
That makes sense. Does that make sense?
Well, yes.
Well,
All while she's talking, I'm thinking of this case we have coming up, and that's why I'm shaking my head, because
It's a confidential case, but it's a mess.
well, while we have you here on this sort of area, can I ask you about that exclusionary rule with the witnesses? That not exclusionary rule, I call that as an attorney. The rule that said the public is excluded from the board's
Deliberation.
not deliberations, but just the first hearing that we're gonna. And I don't even know if you call it hearing. Let's see. Let's look where we had it yesterday.
it's under D, confidentiality during investigation deliberative process, wasn't it?
Yeah, exactly.
Or, yeah, I was gonna say
Or
F.
F.
Yeah.
Yeah, F. Let's see.
Well, no, it was like
It's in
when
the
we-
investigatory process. Let's see.
When we bring in somebody, the normal standard in a court was you can face your accuser. But if we bring somebody in, is it appropriate to have the complainant and the respondent in the room at the same time?
Somewhere here, Julia, it says about excluding the public is the line. Let's see.
Okay, so let me think of all the things that were talked about. One is that, and Dee and I talked about this a bit yesterday, the ethics board does not sit as the trier of fact between a plaintiff and a defendant. You know, the complainant being the plaintiff and the respondent being the defendant. And so it's not analogous to that, because and that's why it's called a notice of a potential violation. The person who's the complainant is not a stakeholder in the action. They are more an agent of the public trust and of the board in that way. And they're the complainant's role is pretty much limited to making the board aware of a problem. And then they don't have an interest in that. And that's why they don't get notice of your outcome until it's posted by the clerk on the web. Because they are not analogous to a plaintiff that has a cause of action to bring in here. So that's the first thing to think about in that. When you're thinking about other things to do.
And that is difficult because almost all the violations, the notice of potential violations we see, the person bringing it has a very vested interest in the outcome. So it's hard to, because they look and seem like a plaintiff.
There have been several exactly like that.
Right, and so you need to diffuse that from them. I mean, because the ethics board isn't to be used. If they want a private right of action against somebody for something they did, they need to file that in court. Because you're here to represent the public trust, not an individual's vested interest. So given that umbrella part, then let's go to the question came up besides the public, which we'll get to, but this question about, is it appropriate to have the complainant and the respondent in at the same time?
And now under what you just
Based
said,
on
I'd
what
say
you just
no.
said, no. Yeah.
Yeah, you don't have to. I mean, it's not mandatory about that, and you get to figure that out.
Yeah,
I mean,
figure
I
out
think
your own
that
way.
that there's no set rule about that. Sometimes that might be appropriate, other times not.
E10 is the record.
For the
E10
public
yeah.
exclusion.
When the board's investigation is conducted in executive session, the public shall be excluded, and the session shall be electronically recorded. Okay, now this is a different thing than the question that was asked about the plaintiff and about the complainant and the respondent being in the same room. What was going on before was that even though the filing of the complaint was confidential, in code, all the deliberations of the board were done in open meeting. And so that was an internal conflict in the former code. What was the point of making the complaint an ethics violation if the whole discussion was open to the public? And so
in the long run, it still is. The recording is still available.
That's right. That's right. But
they have to go extraordinary steps to get the recording.
That's right. But what 10 is about is that the deliberative process needs to be protected. So it's just like analogous to an executive session of a decision-making body, is that you get to ask questions of each other and go over the facts without having the public or the complainant or the respondent there. You don't take action in there, but you get to talk about what needs to happen. And then, like an executive session of a board, you come back out of your deliberation and give your finding. And that's why even in the findings, the public part, the idea was to have some kind of numbering system or something so that when you gave the decision, it didn't name names, but it said, we find that there's a violation, we find blah, blah, blah against the respondent, in this case number 4322, or however you're going to do the numbering system. That's just important, and like I said, it's analogous to other things that are kept from the public during the deliberative process, and it's to protect the people who are having to make hard decisions so that you can ask yourselves the hard questions and test yourselves without having the public or the respondent or the complainant present. And so that's what 10 is about.
Well, is that, Julia? Because this is the investigatory portion is an executive session, and then the next one is deliberations. The executive one is recorded, it's subject to later disclosure. The
Okay, so I
deliberations aren't.
I was looking at E10.
Okay.
F10 says the deliberation should not be.
Okay, so E10 is when the board's investigation is conducted in executive session, the public shall be included.
Shall be
Okay.
excluded.
Yeah, I mean, shall be excluded,
Yeah.
So,
The recording shall be available as a public.
So
Okay,
the
so
so
that,
investigation is when we
ask-
got people in here who are asking them questions.
that's right, right.
And then when we deliberate, we don't record that.
Right, and they're also in executive session, they're not recorded.
That's Dr. Kelly's super secret. Yes.
Right, so,
Right, but
okay, so go ahead.
I was going to say, so in the executive session, that's when you maybe are asking both the person bringing the notice and the respondent questions.
And you can ask them separately, I mean, you don't have to have them in
Yeah,
there at
one
the
or the
same
other.
time.
And I think the concern yesterday that one of these will involve potential police officer as a witness without disclosing anything further. Well, for a police officer to come, they have to generally be subpoenaed, and then their union rep will be there. And that concerned board members, both in terms of confidentiality, because it keeps getting removed out from the bringer of the violation and the respondent.
Okay, so on that, this is how I did think about that, and I'm thinking that the way to manage that is two things. One is the disclosure of confidential information under code is an ethics violation. And so, you know, they need, the people who, you still need to do an investigation. The people that that you need to ask questions of need to be told that it's confidential information, and disclosure of the information is a violation of the ethics code. And you can also ask them to, if you want to, I think, do something akin to what the Ombudsman's office does, is you have them sign something acknowledging that that they've been informed that this is a confidential proceeding, and that a violation of the confidentiality is an ethics violation.
We use something similar in my office right now too. We have to have people sign
Yes.
confidentiality forms.
Yeah. Yeah, and so I don't like to call it a confidentiality agreement, because I don't need their agreement that they're going to keep it. I need their acknowledgement that they were informed that this was a confidential proceeding, and that they're under an obligation, especially if they're an employee. If they're not an employee, and not, I mean, if they're not covered, if they're not within the scope of the ethics code, which covers members of boards, employees, and elected officials, and year after for, you know, a tail on, then I think it's harder, and you might want to think about having them actually sign a confidentiality agreement. But
Remember this came up late last year with our last issue that we went over and over and over for a while before we finally had to say that the complainant actually had violated confidentiality. You know, it was a complainant that wanted to violate confidentiality by publishing articles on online newspapers, and we ended up having to dismiss the whole thing because of that.
Is blogging.
right, and see that, I mean, the thing that you want to keep in mind is that the ethics, what everybody was sensitive about and remains sensitive about, is they don't want the ethics board and ethics complaints to be used for political and other purposes. And so we had an early on situation where no sooner did the code come out, then we had an elected official file a complaint and then hold a press conference. Barbara told him not to hold a press conference. I called him and I said, you're not allowed to hold a press conference on a thing. I said, that in itself is an ethics violation. She says, well, the press is already here. What am I going to do? I said, you're going to have to tell him to go home. Well, he didn't. And so then an ethics complaint was filed against him. And he became the subject of much greater, because it's a big no-no. It's not to be used for that. To make hay. Because that's not the focus is really a preventive focus, to try and have the activities be in line, not to play I gotcha, you know.
Well, I could go right into another question.
Yeah, go ahead.
Well, I was going to say, that brings up when the board comes across what is an obvious violation, like for instance that person who had the press conference, what are the board's either duties, responsibilities, or options with respect to pursuing that violation? Do you wait for a third party? Does someone step off the board, which some of this language suggests, if they want to file?
Right, the board itself, I mean, a member of the board can
Make a notice of potential violation.
yes, and then they just can't hear it. So they have to not, they're recused
So if we want
from
some time
participation. Yes, well, it's not so much time off, because you filed the
it's just
complaint,
all.
and so you have to. Then the board member, is in the role of the respondent, and is in the role of the complainant, kind of just scribing and on the form, indicating what the actions were, and
Well, I
takes
understand that, but we've kind of spoken to one of the board in particular about similar things, where a member of the board was sat on the table and then went around to the other side of the table and made a presentation to their own board.
Right, but we don't have it. We don't allow that. You're
Exactly.
not. It's
Yeah.
spelled out here that you
Yeah.
don't get to do
Yeah.
that.
So that's what Keith is saying. So the ethics board sees this, hears it, says you can't do this. Does the ethics board itself have a further responsibility besides saying you shouldn't do this? This came up in the course of something else, to pursue that further, to make a statement and how would they make that statement? They discover this is this practice on one particular board. It's fairly common.
Okay, so
And it's
the
not
problem is
appropriate.
about the board. Okay, so you found out that some other board was doing something else, and so let's talk about just in general the different duties and things that you can do. On the far end of that, one of the ethics board members can write that up as a potential violation for the rest of the board to consider. And then the board member who files that doesn't sit on the deliberation of that violation.
Right, and we understood that. I guess.
Okay. So that's so before we get into other options, that is one option that this board can do. Do you have a question about that option?
No.
Okay, so then let's look in your code section, and we only got to start this a little bit the last time, starting with 1.15060, duties and powers of the Board of Ethics. Okay, so let's look at B, advice. The board shall perform the following duties to foster and support ethical conduct by employees, appointed members of any municipal authority, and elected officials. So, at the request of the mayor or all these people, you can participate in public work sessions, bring it up. When an individual's actions may be governed by this chapter, which a board member's actions may be covered, consult with and invite the individual on matters involving ethical conduct to include applicability and interpretation of municipal ethics laws. And that can be at their request or without their request. And why this was included in there is that the board under the former code would watch activities of the assembly on record or other activities. They'd hold a meeting. The meetings were public. Notes were taken. It was recorded. They go on and on and on about how disturbing this was that this was happening, all recorded in the notes. And yet nobody would tell the person who was the subject of that concern. And since it was all public, if somebody did come up and see all that stuff and say, oh, the chairman did this and this, and some of it was just not understanding the process of, but oh, geez, we don't like the way so-and-so as chair handles the votes. And never have the person tell them all the notes would be out there, and then they say, well, we just don't think that we've been invited to tell, so we'll just sit here and churn it around and pull out our hair and have all kinds of histrionics. Well, that doesn't work for anybody. And so it was specifically adopted in the code that when you see things like that, then you get to send a letter or invite those people in for training. That's your job. It doesn't have to be like, that's why I said on the far end you can file a complaint. But the idea is just like with any other kind of progression, the mandate is really to try preventive. And so just like with anything else, if they don't have notice, if the board is working without, the board's supposed to be having ethics training. I don't know where we are on making sure that that's something that, as the ethics supervisor, really comes under your shop, is that new board members, before, under the baggage administration, there were each department or something had a point person, and there was a point person within the who's the person that makes the board appointments now?
Jay Jackson.
Yeah, so the Jay Jackson equivalent was trained up, and so whenever any new person came on, they got a whole spiel. They had like a little handout, and they went through the training, and that's really supposed to be going on here.
And there is some of that going on.
Yeah.
Well, this kind of sounds like the letter now that we're sending to the
school
schools.
district. Yep.
Right, but I'm referring to, we may have to bring up some old business with respect to the one board that we had an issue with that we felt was, they were sitting on one side of the table, going around the other side of the table, doing, and participating in the discussion after they made the presentation. Now, admittedly, they recused themselves from the vote.
Right, but if there
it
is
was-
a conflict that requires them to be excused from the vote, that means that there's a conflict significant enough to excuse them from the deliberations.
And that's where we thought there was an issue, and we haven't done anything about it yet.
It's a board that's mostly made up of user groups who come, the members at the table are user groups who come to ask for donations and grants and that kind of thing. So it's got the structure that I think it probably may well have an inherent conflict in the structure.
Yeah.
Right, as opposed to us, we don't all have ethics businesses that we are here as a conflict, but they would have, as you say, they would have an inherent conflict.
Well, and they were voted. They were put on those boards for their expertise was the problem, and their expertise is in
Okay, so let me think.
Well, but just I'm sorry, why?
That's,
One that I can speak of as a former member of the Municipal Aviation Advisory Commission, basically the Merrill Field Commission. There were 5 or 6 different seats on that. And a couple of them were for businesses on Merrill Field. They had an inherent conflict, and if it came up to something for them, at least when I was chair there, they had to step out because we wouldn't allow them to participate in the deliberations on something that they had inherent conflicts in.
which is what the assembly does as well.
Right. The only thing that I would put into that mix is that I think that another way, I think that when you have advisory boards that are there to represent the industry, their decision isn't final. They're just giving advice. And so
Well, in our particular case, it wasn't necessarily final, but they gave, how should I put this? Their decision or their recommendation then went up to, was it planning and zoning?
Yeah, I don't know.
Yeah. Which then takes, gives that heavy weight.
Right. So yeah. So I mean, there, without knowing more.
But there would be a distinction.
Specifics,
It's
but
advisory. I mean, just like in that group, that was an advisory group, which then goes to the body that, the issue is adjudicatory.
I mean, we wrestled with this
Right.
for hours, I think,
Right. So I think that one of the factors in there needs to be how the advisory thing is used for. Then another thing to do is there may be a way, and you just have to think about it. It may be a way to figure out how to say this is the decision without the input of. I mean, what the assembly does is if there is somebody, if there is a way for an assembly member to be able to step down off the dais and give a presentation even though they're an assembly member, and then they have to leave the room. They could own a business, they could be the best person that you have to take input from, but they can't sit on deciding how that input is going to be incorporated and do it. So you want to split it apart. So let's say you on that advisory board, this goes to that question about their deliberation is their thing. So you could set up a mechanism that says, I have a conflict here, but I'm on the board because of my expertise. So what I'd like to be able to do is give you a statement for your consideration as input to you, just as if I was a member of the public weighing in or somebody else, but I'm acknowledging that I have a conflict, and because I have a conflict, I'm not going to be participating in how much weight you give my input, but I shouldn't have to park my common sense at the door for the very reason that you appointed me. So here's my little, statement. I have a conflict. This is my conflict. Because I have a financial interest in the outcome of this blah, blah, blah. But here's what I think you should consider for those of us in my position or on behalf of those. And then you have kind of a split.
That's
split
pretty
thing.
much what we came to. I think I don't recall if we've actually communicated with that board. There was some discussion about a letter that was supposed to go, but I don't recall if we actually did it or not.
Yeah. Okay, so we can do individual, or ethics board can do individual advice, looks like.
Right, and so what happened, where the board has kind of, and I don't know if it's this board or not, but I mean, I've had situations where an assembly member has asked if such and such, some set of facts is compliant. And I will look at it and I'll say, first, it's not my call, because sometimes I've thought that something was totally compliant, and we'll talk about that with this ethics opinion, and then was very glad that I said, but we better ask the board too, because the board really sits in that seat. And so assembly members and other people, unless they ask for an advisory opinion, aren't covered if they're not covered against ethics violation by saying legal counsel said it was okay. They are covered if that says. But then you get into this area where I can't, as an employee or anybody else, I can't ask you to give me an advisory opinion on the actions of somebody else. That is called a notice of violation. But there are times where I'm going to want to know I haven't done anything yet, but I'm going to want to know ahead of time or I'm going to think it's important for my body to know ahead of time on how the ethics board interprets the code, and whether this is a violation or not. And that also comes within that
And we've had several
consulting and advice.
advisory opinions, mostly by the mayor, but we have issued several advisory.
Right, but it can be short of this business about under number 2. It doesn't have to be a formal advisory opinion. The idea was to create something that at your option you could consult with and advise an individual on matters involving ethical conduct to include applicability and interpretation of municipal laws. And that's sort of, a less formal than an advisory opinion, but it's at your option. It's because we've had situations where the board just didn't feel like doing that.
And Julia, can I ask you, before you mentioned about you can ask for yourself, one of the things that this board has taken a very strong stance on is the 1.15080B. The board may also accept a request for an advisory opinion on a matter referred to the board by the municipal clerk or the municipal attorney. This board has taken a pretty strong stance that unless it involves you, no. In other words, a request can't come to the municipal attorney, then asks for an advisory opinion.
Okay, so we talked about that at that meeting, and I disagree with that. That's not what the intent here was. There were 2 areas, and I think that Terry pretty much got this when I explained it that other time. The municipal clerk, there are some things that are going to be systemic, and so even though I can't come in and say, geez, I want to know, I want an advisory opinion on whether Assembly Member X is allowed to do da-da-da-da-da. I can't do that as an Assembly member unless it's about me, and I can't do it as Assembly Council unless it's about me. But the clerk and the municipal attorney's office can both come to the board for advisory opinions about a situation that they do not personally have a vested interest in. It's not about them. We had to have 2, one from the legislative side and one from the executive side, 2 gatekeepers that could come in and ask systemic questions. And so we'll talk,
We had that kind of incident? I don't recall.
Oh, yeah. So, but does that mean, Julia, that you have a question, Assemblyman Y wants to know about Assemblyman X, that you could then run over to Barbara and have her bring the question to the board? I mean, that's what this board was concerned with.
It's not to be used like that. So let's say how it is going to be used.
Okay.
It's used, and let's look at this opinion number 2007-3. So the circumstances here were that traditionally tickets were purchased by tickets to the Mayor's Charity Ball, which is a non-profit organization and not a municipal organization, but it's called the Mayor's Charity Ball because every elected official serves as the head of that and raises money for United Way. So the tickets were $150 a piece. And what would happen is that as part of ML&P's general supportive community functions, the ML&P would buy a table for the administration and a table for the assembly, and it would be, and then the tickets were made available to the assembly. So Barbara comes down to my office and says, we got a new ethics code now, and what do you think? And I looked at it and I go, well, it seems like it should be allowed, but, you know, as an abundance of caution, it's one of those things that you should send in, because then we're all covered, because it's a new board. And so I think that, I don't want to speak for Barbara, but at least in my case, I would have figured that that the interest of assembly members in participating in functions, even if they're comped a $150 ticket, that, you know, having assembly members get out with the public in any kind of event is a good thing and would outweigh any other kind of conflict. Lo and behold, it comes out they met an expedited thing, and the ethics board found just the opposite, that wasn't outweighed, and instead there was a significant benefit, even though it wasn't particularly at election time or anything, but there was a significant benefit to elected officials participating in this way, and it was a gift, and that it shouldn't happen. Okay, so
Okay.
yeah, go ahead.
Just want to interrupt because I have just, a couple meetings ago, we just ruled it was okay for these teachers that got and I think it was our feeling like, oh Lord, they had to go to that thing. I don't think nobody brought it up. Now, of course, that's because other than potentially our chair, nobody was here in 2007, and we haven't done the research to know what the history of.
Right. Well, I think if I was educating you, and I've asked my assistant to do this just because I'm helping train you, is I'm going to have a notebook of all the advisory opinions, and I think they need to be indexed so that we know what they're about, because that is your case history. So that's part of the training.
That would
just
be
like with the
something,
board.
but I've been on the board for a year and a half now, and this is the second training meeting I've had. I'm not complaining. Everybody's done their best, and they've kind of brought us along as we've gone. But I'm thinking.
I did the same thing for the Board of Adjustment. The Board of
We just made some
Adjustment
mistakes,
has history, has enough case history now that Jacqueline in the clerk's office assisted me, because again the clerk's office supports the Board of Adjustments, and we made for each board member a notebook of the prior decisions, because you can't. It's not me reinventing the wheel every single time. So this was a very significant opinion. And I bring it to your attention here because to illustrate two things. One is, this is the kind of opinion that you'd expect the clerk's office or the municipal attorney to bring. And it's, the ethics board received an email request for an advisory opinion from Barbara Grunstein, municipal clerk, requesting that the board expedite decision-making so that she might receive the guidance requested by Friday. So, that was going to involve every single, assembly member and a whole protocol on how these tickets were to be treated. The second thing that I'm bringing this to your attention about is that on gifts, the analysis that the board took there was internally consistent, even though I would have, I wasn't expecting it. It's a very well-reasoned opinion. And what the analysis that the board went through was, one, was it a gift? So they went through the analysis, because the gift is, this is for elected officials, but it's, anything that is given that's less than full value, since they weren't paying for it all. They're not. So in the context of all that stuff there that is. Then they go on to an analysis that incorporates the next piece of guidance that's offered by the ethics code, which is that it's, this was a ticket for a social event. So then the next thing was, there's the standard that says that if it's, if it's not over $50, there's going to be a presumption. So gifts are prohibited. So they looked at it that the other way. So on page, at the bottom of page 3, it says gifts are prohibited if it can be reasonably inferred that the gift is being given to influence the elected official's independence of judgment. And so they found that it was. I wouldn't have found that the charity ball tickets were given to influence an assembly member on any particular action. But I thought the analysis was good in that that's what you want to do. Is it, and so they went and through their factors, the value of the gift, the fact that the elected official would be sitting on the gift giver's table. So they looked at it from ML&P, as the guy who's head of ML&P, and will ML&P be coming up in front of the assembly and doing that?
First, I agree with you until I get to the paragraph that says the second factor, because of the opportunity for unfettered access to these people. That then changes the fact that they will give them, not that they couldn't meet with them at any time, but when you have social events bring something completely different. Actually more business gets done in social events a lot of times than regular business meetings.
Right. So I mean, I'm supporting this opinion because the board made it. I'm just saying that it came as a surprise, but all the more reason why it was terribly important to send it, because it was a reality check to somebody like me who's so, involved from the inside about what the perception is and why it's important to have that public scrutiny and perception, evaluated.
Yeah, citizen board.
Yeah, and why we got a citizen board. And so I think that when they talk about the Anchorage School District employees, and they say school district employee may accept a gift of nominal value. So you apply your reasonable person test to those gifts. If it's not a nominal value, under this opinion, it's suspect. And if a reasonable person could infer that it's being given to influence action, then that's the rule. It can't be kept. Something else has to happen to it. And, I had calls as this was coming into effect from the police department, for instance. They had a vendor. I think the vendor was the coffee supplier or some kind of a thing, and every Christmas time the vendor somehow the coffee became free, where there's usually $1, or the proceeds went, maybe they collected the $1 and the proceeds went someplace to widows and orphans or something, and whatever it was, it seemed like there was a way to manage that better than it was here. Maybe it was that I said, okay, he just needs to make the coffee free because that's consumable on the spot and we understand what he's doing, rather than a monetary gift that was going to be collecting all that money and then giving it to the policeman's retirement fund or whatever it is. But I mean, there are things that people, if they want to do something, they can do it, acknowledge it, their appreciation. If the reason for the gift is to acknowledge appreciation, there are some avenues that can be done. But they can't acknowledge appreciation on such a significant level to the recipient personally that it's not reasonable to think that there won't be some deference given.
Right. Did you recall the disclosure by the individual that went to Chicago on the book publisher the curriculum? And I think we decided it was actually the school district that was getting the benefit, not that individual. But they had a trip paid for them to go to Chicago and back for an education, some sort of educational symposium and whatnot.
which although an individual went, it was the school district that received the benefit, not the individual.
Right, good analysis. I mean, that's
And
your,
we didn't find there was any issue, although actually the question was, how did they get a ticket to Chicago back for $429?
But were it paid directly to the individual versus to the school district?
Yeah, if it was given directly to the individual, then I would.
But it was part of their, it was part of their function in purchasing to do this kind of stuff. But we do have a situation that we're bringing a teacher forward because the teacher received 2 passes anywhere an airline goes. And that's significant.
Right,
Yeah.
absolutely. See, I think that those are the things we're not going to be able to have a code. This is what Dee and I were talking about earlier. Yesterday, is that in public service, with a state and a community as small as we are, the line, whether it's the state ethics line, and in developing this, I talked to the state ethics supervisor quite a bit, and or a municipal one, the line is going to be somewhere, is going to be drawn someplace, and it can, it's discretionary. I mean, there's no. So the assembly drew, kind of a line, and they spent, Barbara will tell you, a year, right? Painful year, back and forth on each thing, on how they were going to sort it.
There was a conflict with the board of ethics, a very strong conflict, because they had come forward they had spent several years writing their version, and then the assembly took about a year to take it all apart and put it in a different package. And so
yeah, when I came, part of the Barbara sat in on my interview for the position, and one of the questions was about how did I have familiarity with ethics codes and stuff like that, and I did from the state side, and had been an ethics supervisor for on behalf of a large state agency when the ethics code came in, and I had been doing workshops because it was a federally funded thing way in advance of that on ethics in federal funded agencies. So I had some background, but I didn't realize until after I took the job that the ethics board and the municipal attorney's office had worked for 5 years through successive municipal attorneys, but basically the same board, came up with a code. It was introduced, the assembly went to work session, and 15 minutes into the work session was disbanded because there was too much controversy over the code, because it was sent in as kind of a one-size-fits-all for employees, elected officials, and contractors, and appointees, and a bunch of other stuff. And the only way that I could figure out how to move it at all was to divide it back up. Then we put it together. There's only like maybe 10 things that are different for each one of those groups, but I had no way to know how that was going to happen unless I divided it up, because there was so much controversy over what was going to apply here and what was going to apply there. So it was really hard. But they slogged through. It was like a mini Title 21 thing, but at least we got closure.
Well, in the end, it was you and Ken. I mean, that was everybody else had bailed. So even when they draw the line, there's going to be lots of room for interpretation, because we can't predict every single thing, and that's where the board comes in, and that's where your reasonable person test on making those distinctions and saying, and at least having some synopsis maybe of what the other opinions had to do to look at, because then you can say, when you're writing formal opinions, can say,
pursuant to this particular.
Yeah, pursuant in contrast, to this one here, just like what you were describing to me, perfect. In this case, we saw that the true beneficiary, and I think that the true beneficiary, whether it's given to the individual person or the school district, I think you get to pierce that and say the true beneficiary of this ticket was a job function that was performed on behalf of the school board without having to pay for it. And the only thing, with any kind of vendor thing, is you got to make sure that the school district isn't unduly influenced by going with that vendor because they pay for it. That's the whole other thing in procurement. People are always wooing business by giving free trips. But that aside, to the individual, they were performing on behalf of the school district, not on their own behalf, and so it wasn't really it might have been a perk, but it wasn't a payoff. And in contrast, in the gifting of mileage credits by an individual whose students are in presumably it's a parent, so whose students are under the management of the school teacher, for the school teacher's use no matter where, is it's in contrast.
What comes up, what's going to come up, I'm afraid, in that one is, okay, I believe, it doesn't say specifically, but because the person, they indicated the taxes they paid for that, to like $179. My gut feeling is this teacher has already used this, so now what? You can't give them back unless they can pay fair value back to the family. And it's like $1,100 or something. And that's where we're kind of, we can go through and say you violated the ethics code, but then what?
That's what I was hoping to.
Because, they can't return it. You can return a gift card if it's inappropriate. You can return some other stuff. But something that's already consumed, as it were, unless we were to direct that they pay the fair value back. And this could be like a mileage ticket. Fair value is, I guess, what it would have been worth. And sometimes you use those miles to go to Seattle. Sometimes you use them to go to, to Mexico. It depends on where you're going.
It seems to me that you may have had a couple of violations if they already used it, which is the timely filing.
Well, we got timely file issues too. We brought that up yesterday.
So that's one thing. You can recommend that disciplinary action be taken for the ethics violation. That's what the ethics board did for when we had an assembly member
Press conference.
The press conference situation, is that the recommendation accepted by the assembly was that person attend ethics training and blah blah blah. So you sometimes you're not going to have an immediate remedy except send it to the school board and the school administration and say that it's their job to figure out an appropriate remedy, and it better include ethics training. And you can do like anything else. You can do public service. You can do community service. They can do.
Become the ethics. Become their school's ethics officer to become.
Yeah. They just. It's it should have some kind of consequence. But like you said, you can't. If they've already done it, you can figure out some kind of a value for it, but some kind of average value, or one thing is, you can buy mileage points.
Yeah.
They're pretty expensive when you buy
They're
them.
hardly ever cheaper than buying a ticket.
But you can. That's a way to value that it's not the mileage. It was given for under here for less than fair value, because fair value is measured by how much it costs
Right,
for
and
either
actually
ticket
the-
or by the mileage
The
points.
person making the disclosure actually put a value of $1,100 and some dollars on there, which,
Yeah, and
yeah,
so it
everybody's
shouldn't have been
eyes.
used, and so now they need to figure out what they're gonna do $1,100 and something dollars worth of something for.
Part of it is though, the school district is getting its arms still, just starting to get its arms around the ethics code. We get a bucket load, Baggage Middle School, the principal goes around and scrounges things from Fred Meyer and all, and she sends way more stuff than we need. There are other schools,
They don't do anything.
which is nothing. We did a chart last year and gave it to the school district, and they're trying to increase the awareness of it and train people, but you know, Carol says when they have those first day of school meetings or before school starts meetings, their teachers are so barraged with all kinds of healthcare forms and all kinds of stuff that this, we don't think that every teacher is getting the action.
you know, they have in-service days on in my opinion, too frequent basis. Isn't that what part of this is for?
I don't know, but it's.
I mean, I've never
Yeah,
sat in on an all-day
I
service.
was so
but-
naive, it just never occurred to me that a teacher would ever think, because here's what they came to us with at the work sessions. And to Ken and I, when we were doing the drafting on it, they said, we want that $50, you know, for an apple, and, you know, we want to have some coverage for the token gifts that teachers get in there.
You mean not the jewelry and the coach purses and whatever else?
Yeah,
say?
yeah, and so it sounded totally reasonable. So you'd think, so it never ever occurred to me that there were people out there giving these massive gifts to teachers, because it's totally out of
The
line.
problem is, it's the public that's giving it to the teacher. And then the teacher is in an awkward position of saying, no, I can't accept this.
But it's not the public; it's the parent of a child.
That's also agreed. That's still a member of the public. But parent of a child, I mean, that's kind of neither. It doesn't change the fact the teacher is still in an awkward position of saying, no, I can't accept this gift. And
When you have pass or fail authority over a student, then it's absolutely unconscionable to accept gifts of any value from that parent, because it taints the actions, positive or negative, that you're taking over that
which is,
over
and
that
we are
student.
getting more and more aggressive with them. That's where our letter is.
So it's
We're going-
not a member of the public just showing appreciation. And I think that that's a different analysis. If you show, if a teacher is disclosing a gift of mileage point tickets from a member of the public who does not have a student in the school district, then I think you have a different
This
a
wasn't
different
the case
analysis.
in that case, then, yeah.
Yeah, but I mean, do you see what I'm saying? I mean, I
And
think
then
that you have to figure out a different and see if that applies or not. But the presumption is on anything over $50, and could be applied even on $50, that
then
it's
even-
given to influence the actions that the teacher has over that student.
At
And
Christmas
other
time, we understand that. Then there's year end, after grades have come out already.
it's a
There's
big
year-end
reward.
gifts.
I give this kid an A, I'm going to get those tickets. That's why positive or negative. I mean, yeah, I just, you
It
know.
almost sounds like that you need to do sort of what the police board does. Police officers that just can't accept anything. And
Yeah,
they're, and they're
I mean,
pretty good about
And Marissa and I went to the school board and had a meeting with them, and they turned us down flat.
Turned you down flat for what?
We told them that we thought that, like the example that the school district of Boston did, zip, zero, no gifts, period. Send a letter to the parents saying there should be no gifts because of the appearance of impropriety. The school board turned us down.
Well, there's a couple of things here. So let's look at this. One of the things that had been percolating for those 5 years before we took on the year was the assembly's position that the ethics code needed to cover the school district employees and they were employees, and that there was, unanimous vote on. So even though the school board has a role there, the ordinances are are under the province of the assembly, not the school board. And so if you look at the code here, in 1.15025 A2, the first sentence is that the school district, whether full-time, part-time, temporary, permanent, excluding elected members of the school board. So the elected members of the school board are not municipal employees because they're elected officials. But the first sentence on .025A2 makes sure that employees are covered. The second sentence says that policies adopted by the Anchorage School Board governing conflict of interest for school board employees shall not be less restrictive than the requirements of this chapter, and shall not relieve employees of the Anchorage employees of the Anchorage School District from obligations of this chapter. So they can't preempt that rule. And if there's a significant problem with them, then the recommendation from the ethics board needs to go to the assembly when you do your annual report, saying this has been, hasn't worked.
I am actually in the process of writing our 2011 or 2010 annual report, and it will be featured.
Right. Okay. So that's what. Now there is one. They made one exception to where where the school board's policies don't have to meet the code, be as restrictive. And I'm going to point that out to you just to show that by making one exception, they specifically didn't accept anything else. And that's on the next page under C, Contemporaneous Service and Employment, number 3. So it's the same section 025, but it's under C, and it's the last sentence of number 3.
Are we talking about like coaches and things?
Well, this was contemporaneous employment, and the school district came in and said, you know, we need to have that reviewed by the supervisor. You know, it should be the supervisor's role to decide if somebody can be a teacher and have a secondary job, because many of our teachers do have secondary jobs. They're unemployed in the blah blah blah, and we want the flexibility as their supervisor. That should be overriding on contemporaneous employment. And so the assembly said, okay, on contemporaneous employment only, then the prohibition against less restrictive requirements in that section is
has
waived.
yet to raise its issue. We've had a couple situations where coaches, one of a rifle team, he's also like the only one in the state who can actually repair the guns, the pellet guns. And we had to, rule on it, and it's a year-by-year basis. I think we decided he didn't have to do it in every single contract.
Right, because he can come in and say, I want a blanket waiver.
Yeah.
We
did that, but we had to discuss it. The school board was here, the purchasing manager for the school was here, and that school district was here, as well as the purchasing, and they explained to him. So we understand that it appears that there's an apparent conflict, and this is how we're choosing to handle it.
Right. So on things like that, I think that's right. It's like the equivalent of the school district saying, we need a waiver. Okay. But on gifts, that's a big taboo, and it's not because it puts, I'm not Catholic, but when I was in Fairbanks, I had a child enrolled in Catholic school. And the uniform in Fairbanks was t-shirts and jeans. And
in a Catholic school?
In a Catholic school, t-shirt and jeans.
That was different than I went to school.
I know, I was surprised. And so and it was for intermediate school, and so when the principal was explaining this to my son, what he said was, it's t-shirt and jeans, no big jeans, no designer jeans, he said, because we don't want any kid to feel like they're not equal here. And many of these parents are making huge sacrifice to enroll their kids in here, and so we're not having that. And the big genes are a health and safety problem anyway when you got to evacuate for fire drill and all that. And it was like the most perfect, sensical thing. And that's the same thing with those gifts to those teachers. No kid in there and no parent in there should feel that their kid is on an unequal basis because they can't afford the vouchers.
Or the teacher knows they can't afford, but they choose not to.
Well,
Yeah.
I guess if we were getting disclosures from all the schools, I guess I'd be claiming a little more aggressive, but the school district, in my opinion, has not managed it. That's part of our letter. The school district has not managed it appropriately because we get it was 10% of the schools that our report said.
I forget.
I'll need to.
Well, the other thing that you can do is that you can accept a request for an advisory opinion on school teacher gifts from the municipal attorney. That is a systemic, that's exactly what that's for. And then you publish that advisory opinion. And it says this is how we're interpreting it, and you use that.
Yeah, 2011-2.
Yeah, and you do an analysis, and the attorney helps you.
I think she already knows where we're going.
Yeah, but with tying in some of the other advisory opinions here, but that analysis is, and those things, and those public policy, just what we've talked about, just like what Barbara said, either that they can't afford it and not understand, or they can afford it and they don't choose to. No kid should be in a position, and no parent should be in a position of a public school of thinking that they have to compete with other parents on rewarding the teacher.
Well, then there's that one family. We had to wonder if the parents liked one kid better than the other one.
They gave more to one teacher than the other. Yeah.
Or three siblings.
All these things. And so the thing is, these are. I mean, it sounds. But these are. But those are examples that you can build into your analysis, because it sends a message that it can send all kinds of miscuing messages.
Because if we wake up the other 90% of the principals out there, we're not enforcing it. If I'm assuming the way it works in the school, that the principal is the boss and all the teachers report to the principal, they're not enforcing the ethics rules and the disclosure in their schools. And I find it odd that it's just like 10% of the schools, they're only getting gifts. As to the whole board. So what the superintendent actually has the report, and she's dealing with it.
Right, but I just think that as part of your preventive role here in getting the word out, it's good to issue something that says this is what we see. This is how we think this is. The municipal attorney has asked for taking it on ourselves. I mean, but I think it's really important to be proactive and not have people be in the "I got you," but to get the word out. Then they can post it. They can post it.
Well, I think the school district persons that I've talked to now, with your letter that's going out to 15 people and bringing one or two people back before the board will spread like wildfire.
And we were
the school district.
And that was to kind of shoot across. That was designed, by us, I think, to shoot send a shot across the bow to let them okay, guys, we're serious about this. I have no idea what we're going to do to the teacher that got the tickets, but that's up to the board to decide.
Well, let me ask you that real quick. The 1.15.100 sanctions, referrals, and corrective action. This is when you're
1.15100,
right toward almost the very end. This seems to be when you're when you're asking the municipality or school board, the assembly or school board, to do things that you would never have power to do. Rescind a contract, discipline an employee. The ethics board doesn't have the ability to do that. They can make recommendations.
Right, but the ethics board can do public and private letters of admonishment.
Okay, so I was going to bring that.
So I mean that,
So,
and they can recommend, they can do corrective action, and they can recommend, okay, where the board has recommended corrective action to the respondent, because they don't necessarily report to you, and the respondent has agreed. So another thing, this is what you get to do. You get to, as part of there are things that are potential, some things you get as a disclosure, and then that triggers your review. Other things you get as a potential violation, which triggers a review and investigation. Some things on a disclosure can go into what we talked about when we started the meeting today, can go into taking on a potential violation, the board itself. Okay, so there's a provision that was not in the ethics code before, and but is analogous to provisions that are under state law. And in the state system, there isn't a public board. There's an assistant attorney general.
I misunderstood. I thought there was a state board. Wait,
There's not a state ethics board.
Okay.
There is on the executive side. So let me back up. On the state side, there's a code, a chapter in Title 36 that's called the Executive Employees Ethics Code or something like that, Ethics Act, and that covers the executive branch of government. Then in the legislature, there's another code for the legislature. So let's talk about because what we did, we're not so big that we have that big thing, so we did kind of one code. So within the executive branch of government, there is not an ethics board. There's the different state boards, State Board of Personnel and different things like that, but there's no ethics board. There is, by code, a full-time attorney position who is the ethics officer for the state and does the investigations, makes the rulings, presents things adjudicatory to the personnel board when they're taking disciplinary action and stuff like that. Okay, so there isn't a citizen board, but we have a tradition of a citizen board. So the citizen board here takes the place of that full-time paid attorney who is the ethics officer in code. And one of the things that ethics officer in code gets to do, and this board now gets to do, is to have a resolution process. So it is covered in subsection H of 1.15070. So it's housed under potential violations. So the board can formulate a proposed resolution and settlement of a violation during the investigation or after deliberation. And the respondent's required to kind of admit the violation, and then the proposed resolution and settlement has to include the admitted violation, remedial actions, and preventive actions. And then I think there's a provision in here that you can't do it in secret. I mean, you get to do it privately, but there has to be a written report, just like there would be for a potential violation, and the report becomes public that this is what they did. Okay, so by analogy, when you have these disclosures, I think that you can talk about kind of a informal remedial thing with the school administrators, with the person themselves, with to say this is how bad it is, because otherwise you're going to be in a situation of needing to file a potential violation. So this is even before that, because I mean, like I said, just the same way that I was surprised at the public reaction about going to the mayor's charity ball. I'm just equally surprised that there's this ongoing thing with kids and gifts when, like I said,
it's a lot bigger than I think we know.
Yeah, yeah. I mean, you've hit the tip of the iceberg. So
We're gonna turn it over.
yeah, you're gonna turn it over.
Tsunami.
Well, now, in that particular case, in the case you said where the municipal attorney should potentially bring something to the clerk, and we can work on it.
Well, it comes from the municipal attorney's office or the clerk.
Right.
Each
I
of
guess
them have
I guess
it.
my
So-
little concern is about this is if you can't advise us if it came the other way, maybe it would work better, because she can't advise us on a particular case if she's the one who brought the complaint or asked for advice, can't she?
I'm just asking for,
Because we're asking her for interpretations of law and whatnot, and if she's the one.
I think that it has to be done in the name of the municipal attorney.
Okay.
So that's Dennis Wheeler.
All right.
I mean, that's what the code says, the municipal attorney, not just anybody from the municipal attorney's office, just like it's
Okay.
the municipal clerk, and not just anybody under the municipal clerk's office.
All right.
And I agree that there's potentially, always there was potentially some kind of conflict in the same municipal attorney being both the advisor to the board and the designated ethics officer for the administration. And that was surprising to me, because I think that should be two different people. Actually, I think you should be advised by somebody who's not, but nobody's brought that up as a problem yet, and it's allowed for consistency of advice. So the same person that's advising you is also advising when there are appointed ethics. So it's a different way to do it. But I think that it's going to be okay if Dennis asks for an advisory
All right.
opinion.
by the way, all the departments, not all, most of the departments do have their appointed ethics officers, and until about the last 3 months, we used to meet on a monthly basis, and they had all sorts of questions funneled up through them as well. And that was much more informal, we were just a group that could discuss things.
Right.
It's a very sophisticated group, as it turns out. They're generally 1 or 2 steps under the department heads in all the levels.
Was there anything else we needed to bring up?
Are you going to start that again?
Yes.
It might be a good idea to include Eric. It might be a good idea to include Eric
Yeah, that's not a
Thompson.
bad idea.
There was only one other thing that Marissa brought up, and that was the
dates.
all the dates there's so many different
Deadline dates.
deadline dates.
Yeah,
she
this is
gave a long list of deadline dates.
Now only a few of those apply to the ethics board. Most of those are reporting dates, and those vary wildly. I guess your concern has always been that no one's following virtually any of them. Very few are followed at all. Some of the disclosures are made. But I think Marissa had there's sort of 2 questions. One is, we have all these different deadlines for the people who are supposed to be disclosing, but then your own internal dates were confusing. But combining the 2 dates is confusing. The 2 groups are different processes.
I think one of the biggest things is, since we only meet once a month, that 30-day deadline
We've only
comes
missed
very,
one meeting that I'm aware of.
comes very
in the
fast.
last couple of years, but there was because of a conflict of schedule. And then I appreciate what you were saying about we needed to have consistent board meetings at consistent times.
Public
Although we
notice.
seem like we're meeting an awful lot lately because of what's coming up. But
Okay, so what's the internal deadline? Okay, so campaign period, completion of action. Okay, board shall complete action on notification of potential violations and investigations within 90 days of filing. You want longer?
Well, here's what happens though. They get the, let's say the report comes in to Barbara, the ethics board gets it at their next meeting 2 weeks later, then the next meeting is to interview people, then there's got to be a draft. It's an easy 3 months.
So
Because of monthly meetings.
I think that I think it's important for the code deadlines to work for the board. I think that some of the deadlines were on when things have to be filed, including some kind of, there's also in the ethics code some kind of thing that doesn't even come here, but things that go to Barbara, on the disclosures. And,
Well, in the one case we were talking about disclosure that was 3 months or more than 3 months late.
I think it
No, it was October.
No, it
to
was
now.
signed.
it was signed in October and faxed to my office in March.
But is that the school's fault for the school secretary who didn't fax it from there, or the teacher's fault?
Who knows? We don't know that. It could be either one. The teacher could have signed
Yeah,
it.
I guess the generally it's the person's responsibility to ensure that it gets to the board, and it should be filed with the board, and so part of that just needs to be worked out on things. If when on the 90 days, one change could be that it's 90. This is written as 90 days of filing, but maybe you want it to be 90 days of the first board meeting, on it. Yeah. And so things like that, I think the best thing, we've been successful under the prior boards and under the prior assembly in having housekeeping, things like that just go right through the assembly, because the assembly always thought that they were going to have to make changes, and I think they're all surprised. At least I am. Are you surprised that there haven't been more changes?
There's been talk of a major rewrite again, but nobody wants to take it out, I think.
Well, and we have a meeting on the 1st of April because we're up against a deadline on the 4th of April. Because we not only have used up our 90 days, but we're real close to using up our 60-day extension that's allowed.
Mm-hmm.
And it's partially because, as a citizens board, we have people who are, working. The gentleman's not here because he's, dispatched someplace else, and he wasn't able to get his person to the hearing. It was supposed to have been, actually yesterday he was supposed to have the hearing, and he forgot it the previous time. So it's.
Well, I think, I'm sorry.
No, that's all.
I think Julia's suggestion is, in the municipality, sometimes we wait for major rewrites, and in this case, maybe there's a couple really quick fixes, where we just get them through, get them done.
I don't know that I ever thought that we could ask for some householding. Or not householding.
There was an ordinance
housekeeping.
in the code.
I need householding.
Yeah.
I wonder, do our...
Yeah, and I think that other things are, like in a court system, when the action goes forward, and then there's, like, even under the most stringent 120-day speedy trial rule, when the other parties' actions delay things, and they're not counted against the 90 days. I mean, the time frame for the board. So,
like subpoenaing those officers is going to take time.
Well, and that in some degree, even the situation with the school district. I mean, when we bring somebody in from the school district, they're more likely, they could potentially come with their representative as well.
Mm-hmm. Absolutely.
And why would that be why would officers have any different, why would they need to be subpoenaed but not the school teacher?
Of their CBA directly.
The CBA requires this?
Well, that's the interpretation by the
Okay.
collective bargaining unit, that's required under their CBA. Before anything that could even remotely result in discipline, you have to give notice to the union representative. And because of that, the administration generally won't order an officer to appear, so therefore they have to be subpoenaed. It's a long way.
And in other times, I mean, I know in other venues, so that you don't have employees, so that all employees are under the same group, it's oftentimes better to just have the internal rule be you require a subpoena, because then it protects them also against retaliation if they're being asked to testify against
And that's
or
an
about some other
administrative
things, so.
administrative subpoena through the clerk's office.
Yeah.
I don't think we've ever used it.
I know we have a form upstairs,
Well,
I've
yeah.
seen it, but,
We may be.
Yeah.
well, we will have to for those officers. And do you know if the monthly bulletins, employee bulletins go out, do those go to the school district, do we know?
I doubt it. I really doubt it.
Because we have those monthly newsletters go out too, in terms of reminding people about these economic disclosures. And I don't.
Yeah, I
think
was wondering
2/3
that
of
too,
the
if the
city
school
isn't aware
district-
that they should be doing that.
I thought I better decide mine since I was on the board.
Yeah. I mean, do you think that those apply to elected officials? You're not thinking that they
Mhm.
could apply to you as well. Well, Julia, thank you.
You bet.
Thank you very much.
Yeah, you're
Which
totally helpful.
actually that brought up something I meant to ask you about this last time. We had one by Dana Pruse, a disclosure, which I've seen at least twice before, and the only reason I know about it is because I know him personally. So I recognized the name when I saw it again.
It was
Yeah, it was
yesterday's
yesterday's
packet.
packet, which I don't have because I don't like to get packets because they're covered. So I just thought that was odd that we had
It may have been a correction, I don't know.
I mean, I didn't put
Okay,
right
because
on
it
that.
was just it was dated last October, I believe. But it was another disclosure.
Maybe it's gotten something
I
there.
mean, it wasn't a big deal. I thought it was odd.
Well, thank you very much.
Thank you, Julia.